In this courtroom session, one judge moves through a line of defendants facing very real consequences, from mental health commitments to murder charges to young offenders on the edge of prison time. Every file on her desk is a life about to change, and every decision she makes will follow them for years.
Okay, I'm writing it all on my docket.
Here, I was going to say,
So I'll write it again.
you don't have to.
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
Okay, thanks.
I redid the paperwork on my judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch?
I don't know what you mean, sworn.
Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Judge, that one, I've gone next door to check to see what Mr. Cole got.
Oh, okay.
But he hasn't got
We're
it
waiting
yet.
on that. I need to make that note. Okay. What about Denzel Spikes?
Yeah, that was on my plea.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Yes. Let's take care of Miss Delaney, Mr. Parker.
The first case isn't about guilt or innocence at all. It's about whether a woman with severe mental illness can even stand trial. Doctors say she still isn't stable, and with no outpatient facility available, the judge is forced to order a long-term inpatient commitment just to keep her and the community safe.
And this is one where they say outpatient, but I don't have,
Do we think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 of the list to be done.
For you?
I don't
need
know.
one.
I'll go for a while. Yeah, why not? Is it a state jail felony or is it a third? We also need to watch out for,
Statute.
okay. Yeah,
Because it doesn't look as if it's a public danger.
right.
I thought we just did something September.
This one we were trying to get over there.
Oh, yeah. Oh, that's right.
No, why they have this journal? It's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration.
Next up, a man charged with murder. Both sides tell the judge they're close to a deal, but not quite there. Instead of rushing a plea on a life-changing charge, she grants one final reset. and warns that after this, the case is going straight to trial.
See, in addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding it with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Miss Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently. And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated will experience deterioration and the ability to function independently. That's it. It's another one. Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a civil commitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let.
Then a young man stands before the court, admitting he assaulted a peace officer and committed a robbery on the very same day. On paper, he's getting a break. 10 years of deferred probation instead of prison time. But that mercy comes with strict rules, and a warning that any slip could send him straight to a cell.
We'll get Ms. Delaney back, otherwise we will wait for their report and have a hearing at that time. Ms. Delaney can go back. Ms. Perazzo, are you ready on Trevon Alexander? Good morning, sir. Are you Trevon Alexander? And Mr. Alexander, I'm sorry? Good morning. And so Mr. Alexander is charged in cause number 25 DCCR 0831 with murder. And Ms. Perazzo, what is the announcement?
Your Honor, if we could have just one more short reset so Mr. Smith and I can try to work out an agreement. We have received an offer.
You've received all the discovery?
Yes, ma'am. There are no discovery issues.
Okay, so what I'll do is this will be the final reset. I'll give you some time to do that. Mr. Alexander, at the next court date, if you guys have reached an agreement, we'll take care of it on that date. If not, we'll get your case set for trial. All right, you can go back with the bailiff. Well, that's great, except that he just got it all done.
Okay, I'm just.
Okay, I'll get to it in just a second. It's not even here yet. Mr. Burbank, on Destiny Williams.
Yes, Your Honor. She was in the back.
And Mr. Kimler, I'll get to it as soon as I can.
Want to take it?
Nope. I don't have it anyway. But
I don't have the paperwork. Never mind. We're pleading
For
to-
what?
We're pleading to counts 1 and 3.
okay.
You want paperwork?
I don't know. Do I want paperwork? Is it for what's it for?
For an update.
Update.
Yeah. Yeah.
Just,
Yeah. I threw you off on the other one. He's gonna have to do paperwork with her.
you didn't throw me off.
When his lawyer quietly asks for a lower bond, the judge looks at his record and the facts of the case and says no. Before she considers any release, she wants full assessments for substance abuse and mental health. She's not just thinking about him. She's thinking about what happens if he walks back out that door.
I mean, I know it's a new thing, this whole paperwork silliness when we have to do something, but
Oh, my, you know.
you're getting old. Okay, let's see. So how many are we doing on Branch? Jeremiah Branch? 8-2 and 8-5. Handle.
Oh, just give them to Judge.
Good morning. Are you Jeremiah Branch? Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. Branch, in cause number 25 DCCR 1382, you're charged with the second-degree felony offense of assault on a peace officer from September 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 25, DCCR 1385, you're charged with the second-degree felony offense of robbery from September 17th of 2025. And how do you plead to that charge? Are you also pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreements in each of your cases are for 10-year deferred probations, $500 fine in each case. You would be required to follow all of the rules and conditions of probation, and there would be dismissals in cause numbers 25 DCCR 1383 and 1384. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Branch is not competent?
Your Honor, I believe he meets the legal standards for no competency.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Mr. Smith, what is your position with regard to bond reduction based on the nature of these plea agreements? I just printed out a PC.
Not
Let me take a look at this one. Good grief. Okay, so Mr. Branch, is there any criminal history? How old are you?
It has 32.
There is criminal history?
One state jail judge.
I think I'm not going to adjust the bonds due to the nature of the offense. I have taken a look at the probable cause affidavit. I just want to make sure that there's a substance abuse assessment done, make sure there's no issues with that and or any mental health issues that would need to be addressed. If we can also take a look at any mental health issues so that I know at sentencing if there's any other requirements that I would want to impose before release so that we don't end up with this kind of issue again. You can go back with the bailiff. Denzel Spikes, Mr. Lewis. And no paperwork on this?
Yes, shoot paperwork on.
All right, just have a seat, and I don't have it yet. Let's see, we took care of Lazo, right? Okay, give me a minute for. Mr. Rojas, you have a Byron DeQueer. 2 cases. I'll print the first, if you can print the second, please. Just a second. Good morning, are you Byron DeQueer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second. to get this.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the M12P.
Okay,
There's like 13 counts.
what do you want to go forward on?
We'll go with the first 7.
Okay, state's gonna proceed on 1 through 7 in each case. Okay. And, Mr. DeQueer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 2nd of 2024 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing? Huh? I feel like yours is closer, but it takes longer to print than mine. Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, second-degree felony, and that was also a deferred probation for 10 years. Is that correct? Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
Later, a 19-year-old steps up, acting like the rules don't apply to him, even in jail. The judge reads incident after incident: disrespect, rule breaking, childish behavior. Then she draws a hard line. Follow the rules on probation and complete the program, or spend up to 10 years in prison. At 19, he's told point blank, this is the decision that will shape the rest of his life.
Count 6 in each case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. DeCuire is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. And cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23, DCCR 1449, also find counts 1 through 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, it's a sentencing. Taylon Douglas.
Instead of sending him away, the judge holds back a felony conviction and offers 3 years of probation with intensive treatment. If he succeeds, the case is dismissed and he walks away without a felony on his record. If he fails, that same choice turns into years behind bars. 1 file, 2 futures, and he's the one who decides which one he gets.
All right, you're Taylor Douglas. And Mr. Douglas was previously in court, entered a plea of guilty to the 3rd-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Any additions or corrections?
Only that court is inclined to follow judges, certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them.
I'm not, but I take your word for them.
Okay. You don't like to follow rules, do you?
I follow rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like stuff,
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Telling them they're white and ugly.
That's what they said, I said?
Mm-hmm.
I don't know, I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation, where you have to follow rules whether you like them or not, because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? So you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this, the crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to...
Another defendant chooses a different path, a plea to a reduced misdemeanor assault. No long probation, no second chance program. He takes a straight 1-year sentence in the county jail. For some people, a short, hard stretch behind bars feels safer than risking years on probation under this judge's watch.
Follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon. And then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony, in reviewing of his incident reports from the PSI themselves and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're doing there.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there, or they have to have those out of the house or locked where you cannot have access to them. Do you understand? Okay, you go back with the bailiff now. Michael Dyer, Mr. Rojas.
Then comes one of the heaviest cases of the day. A man accused of sexual assault, facing up to 20 years if a jury convicts him. The state offers 15 years in prison if he'll plead guilty. Standing in front of the judge, he does the opposite. Signs a rejection and chooses to go to trial, gambling his future on a verdict instead of a deal.
Good morning. Are you Michael Dyer? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to, what?
I'm sorry.
Yeah, California County.
I'm sorry. There was just some alternative offers and
Okay.
he had,
We originally
Indicated
filled out paperwork,
one and then
right. We
the other.
originally filled out paperwork on the felony, but then he
Okay.
changed his mind to the misdemeanor.
Okay, so I'm going to hand you the trial court certification, again, that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Yeah, I didn't say it, sorry about that.
and Judge, he had the lowest level of culpability in that case. There was another
Thank you.
individual who was actually doing it wrong.
Thank you.
Later, a man who once walked out of this courtroom on deferred probation comes back in chains. Multiple drug tests show meth, ecstasy, and more. New weapons charges. New arrests for running from police, not once but twice. This time, the judge revokes his deal and sends him to prison for 8 years. The second chance file is officially closed.
Marco Gomez, Mr. Rojas.
Come in.
I can see that.
Good morning. Are you Marco Gomez?
Yes.
And Mr. Gomez, in cause number 21-36534, you're charged with a second-degree felony offense of sexual assault from March 26 of 2020. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, he told me that I have to sign it today because I don't have, I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Is it the same thing, I still gotta go to trial no matter what?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial,
And are you okay if I appoint a new attorney today?
I guess I can go with this one.
You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what we did her, Judge. She said she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Gerodrick Randall, this is sentencing. I'm about to have to take a break.
We came for a sentencing before, you rejected that because we had some new cases. We have a new plea.
Oh, okay, got it. Okay, so
They're not new cases in this court, no, but he picked up some new cases.
okay. So we already went through. All right, are you Gerodrick Randall?
He's not.
And so did I just reset it or did I?
Hi.
What did I-
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. It was reset for an updated report. Then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And so I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We need to
that.
enter pleas to that, and then we have an agreement if the court's okay with it.
Okay. All right. Will he waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of them.
And Your Honor, with your permission, we've agreed to plead to 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses, all
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025, and is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025, and is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025, and is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025, and is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025, and is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to lesser.
I think we did lesser
robbery.
included.
Let me double check. And Maybe because he's one of several co-defendants in that case, and I know at least one of them was pled to a lesser.
I asked that we did plead him to a lesser included robbery back in August of '24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
It was put down to judge robbery.
Okay. Does the state want to,
Yes, Your Honor, I'd ask that I be allowed to amend the motion to take out aggravated, reflect the original.
any objection to that?
No objection.
So I'm going to go back and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas of true to counts 1, 2, 3, 10, and 11. Find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court's just going to, I just need about a 5-10 minute break. We'll be in short recess.
All right, court's in recess.
Another probationer admits his violations and watches his safety net disappear. Instead of extended supervision, the judge cuts it off and hands down a 2-year prison sentence. For some, the road from "we'll work with you" to "you're going to prison" is only a few bad choices long. Finally, a man already on deferred probation for aggravated assault with a deadly weapon returns, charged with yet another aggravated assault. Even with arguments about mutual combat and a lighter new case, the judge can't ignore the pattern. Same violence, same weapons, same danger.
New paperwork on the motion, which was pled with enhancements to a TDC felony, correct?
Yes, ma'am. And he pled true to 1, 2, and 5. They abandoned 3 and 4.
Okay. Let me get it pulled up. So again, I have paperwork here on the computer that you've now signed with Mr. Parker. Did you go over that again with him before you signed it?
Yes, ma'am, she did.
And do you fully understand it?
Yes, ma'am.
And you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
1,
objection?
it's admitted. Any evidence that Mr. Balsamo is not competent?
Excuse me, no, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 5 freely and voluntarily. Find those counts true find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 2 years in the Texas Department of Criminal Justice. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I can't remember when we started going over that.
Go through the whole thing.
Huh?
No, he didn't go through that part.
In 2021, I don't know if that we were doing that yet. And so because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
And let's see, Denzel Spikes, Mr. Lewis, Mr. Rojas, I'm gonna get to your, I've got your paper in front of me now. Y'all all have too much, sorry, it's just, I'm not going in any kind of order today. So I see paperwork on the MTRP, but not the new case.
We did them both.
Denzel Spikes. Okay, you're Denzel Spikes. Will your client waive the formal reading of the motion and the indictment?
He does, yeah.
Judge, we're just proceed on count one, on allegation number one, we'll abandon the rest. That is the condition.
Mr. Spikes, in cause number 25 DCCR 0921, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm gonna need some explanation.
On
The punishment,
his 3, Judge,
he's on probation for aggravated assault with a deadly weapon, commits another one?
the newest one was not as egregious as it seems. It was a kind of a mutual combat, but
Okay, let me look at the,
therefore we're proceeding on that with the lower offer due to the nature of it, but not to continue him on probation.
okay, give me a second. So give me just a second, I'm going through a couple things. Okay. All right, so I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial?
In the end, she finds his violation true, convicts him on the new case, and sends him to prison on both. 3 years each, with a deadly weapon finding that will follow him for the rest of his life. Once that box is checked, parole gets harder, time feels longer, and every future judge sees exactly what he did.
Of naturalization under federal law.
Yes, ma'am.
Look at one more thing before I do this. Let's see, 24. I'm printing something. Bless you. I'm just looking now at the PC from the original case. I'm looking at the PC from the new case. Let me see if I can go back. I'm also going to take a look real quick at the PSI. I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people.
From mental health commitments to murder charges, from teenage defiance to repeat violence, this docket shows what really happens when people run out of chances. One judge, one courtroom, and a line of defendants learning the same lesson in different ways. The law might give you a break once, but it never forgets what you do with it.